What is up, boonies? All right, so we've gone through the first attorney and all the activity that he did. And if you missed that video, I will attach it at the end of this one so that you can find it. I've also attached in the comments below all of the videos we've done on this case. It's a playlist. Please make sure you go in and check it out so you don't miss anything. So, as we get to attorney number 3, I wanted to go over what is on the docket. I'm opening up each item. I want to see what happened. I want to see what each attorney did. I want to see what the JAC has. I want to. I'm not going to read all the letters. I think what I'm going to do. I have not personally on my channel read all the letters. I honestly, I haven't had the patience with Sarah to do it. I'm just going to be honest. Maybe I'll get in a mood. I'm going to go ahead and download them as I'm going through everything, and maybe one day eventually I'll put them up, but I know everybody else on YouTube's already done it. So do you really need mine? But what I'm going to do is as we hit these letters in the docket, I'm going to touch on some of the things that she says in there because it does kind of it's part of what's happening as we go through the activities. Again, if you missed the first video, this is me going through everything because I want to know what each attorney that worked with her did for her while they were on her case. And we know there are a lot of attorneys, so it's going to take a bit. So let's get to it. All right. Now, the first notes I've made here, I'm not going to pull these up yet because I just made notes on it, but where we left off with the last video, Padilla requested a motion to withdraw, and he was relieved on 4/29. Judge Wooten held a court to discuss the withdrawal motion request from Padilla, and he granted it. And he also did a reschedule of the trial date. Now, I would like to say this about what Padilla did. When he sent in his motion to withdraw, even though it was quite obvious that there were so many things he wanted to say that he could not, he did request a continuance on her behalf in doing so. Now, maybe that's just part of, being a good lawyer. I don't know, but kudos to him. So on 4/5, it kind of jumps around a little bit. On 4/5, the individuals scheduled for the May 3rd depositions, which were supposed to be done by Padilla because he's the one that set us all up on a Zoom, those people were informed that someone for the defense would still take their depositions. So they were still going to have ASA was going to be there, that somebody representing the court there. So they were still going to be able to do those, even though there may not be an attorney for Sarah in the room. Those people, there was 4 of them: the medical examiner, Detective Chelsea, I know I'm saying it right, Copsel, I think it's Copsel. Diana Johnson, she was the one that worked at the auto body shop where we believe that Sarah took her vehicle after hitting someone with her vehicle while drinking and driving. Again, that last sentence, completely speculation on my part. I'm not sure it happened, but why on earth would they bring the body shop in? And the only thing I can figure is that one statement that was made by Juan Torrez, George's brother, who said that he thought that Sarah had hit someone with her car. Then also the 4th person would be the other detective, which interviewed Sarah and has been the lead detective on the case, Scott Lowen, one of the lead detectives, him and Copsel. So then on 4/26 of, oh, by the way, I completely forgot, you guys. I'm in the year of 2022. I haven't been saying that, I don't think, when I was giving you dates, first 3 items here, but this is 2022. Sarah has now been in jail for 2 years at least because she was arrested in February of 2020. On 4/26 of 2022, the docket receives the first handwritten letter from Suitcase Sarah. It is dated 4/20 of 2022. Let me open that up really quick. Again, I'm not going to read it, but I just want to look through it really quick and see if there's anything I wanted to share with you guys about what was said in there. Let's just take a quick look-see. Another reminder too, guys, this is the 3rd judge on the case. It's Judge Wayne Wooten. So in this letter, she's completely flabbergasted by the withdrawal of Padilla. Like she never saw it coming. Well, I guess we've already kind of figured out Sarah does not know how to read a room, but she's basically just expressing her utter surprise in this. She says, "Forgive me if this is the wrong approach in contacting you directly, but I wanted you to be fully aware of the magnitude of my shock and disappointment in the betrayal of Mr. Padilla, as I have not in any way, by anyone, been provided any explanation for the aforementioned withdrawal," etc. Again, can't read a room. "I unfortunately had to learn of these documents by my former husband when calling to speak with my son, after making a commitment to me as my attorney over the past 2 years and 2 months ongoing to fully and sufficiently represent me, also being made to believe we were a team. I am completely blindsided. Nonetheless," I don't think nonetheless needs to be there, Sarah, "in how this was and is being handled by a professional, I do not understand." Well, the man that you said you were a teammate of was not getting paid. He took your BS as long as he possibly could before realizing that you were more of a pain in the neck than you were worth. Because like we thought, he's going to get some kind of any attorney that's going to go in and give this case a pro bono thought, you know what? I'm going to get a little bit of exposure out of this case. It'll be good for the firm. Even though we know she's going down because the idiot recorded the crime. Because he was in Miami and Sarah's in Orlando, which is about a 2-hour drive. Now, with that being said, Your Honor, I'm graciously requesting to be included and present, please, at this hearing on Friday, April the 29th. She wants to learn more and also explain the ongoing legitimate hindrances she's been facing. Nobody else is facing it, just her, along with her inability to amply progress in the preparation of her upcoming trial and future. In her opinion, these concerns are what spurred these requests by my attorney in the first place. In her opinion, these concerns. So basically, her trying to be involved, her wanting to be constantly involved, her saying how things were going to be done. Yeah, you're probably right, Sarah. She wants to fight for her truth. So let's throw him under the bus because he doesn't agree with you now. She says she's flying blind. Aw, she could write a book. All of her little metaphors. "I don't know the process, procedure, or protocol for any of this since I have never been in the current situation I am in." Well, let's hope not, Sarah, because let's face it, if you were, you wouldn't have been able to be in another one. You'd still be in jail. She wants to meet with the judge to further explain any and all questions or concerns whomever may have. She wants to meet with the judge to explain herself. So it's kind of funny in this letter because, Sarah's letters, each and every one of them target somebody, right? It's never her. It's never her. But there's always a target. Sometimes there's multiple targets. On this particular one, though, I have to say she didn't target the judge. So, good for her, I guess, on that one. Because usually the judge, of course, this is his first letter she's sending him. Now, I think when he doesn't respond the way she wants him to respond after this first letter, then she starts getting angry with him. So let's go on to the next document on the docket. They had a hearing on the 29th, which she was speaking of. Now here it says court minutes. See if they gave us any court minutes. No, they did not. I hate when they do that. Obviously they're attached, but we can't see them. It just says court reserves the ruling on the motion to withdraw. Defense to submit amended motion. Oh, so he didn't let him off the hook right then and there. Parties to coordinate with judicial assistance for the week of 5/9. Probably what happened. Poor Padilla. He had to, because he was like the first one in line, he had to really plead his case on why he wanted out. Because, he'd been on it for 2 years. So a judge is going to want to say, wait a minute, we're ready to roll into court here soon. What's going on? So I get that. I get why the judge would want a little bit more. So he asked for him to go back and amend the motion. So now they're saying, okay, well, we're going to touch base again on May 9th and see where we're at then. And once again, I forgot to share it. Here it is right here. Okay, wait a minute. I take back what I just said because now that I'm looking at it, on the same date, And again, I didn't see that hearing. That's something we'll do later, maybe go through the hearings if whatever we can that was televised, because for a long time they weren't televising all of her hearings. I mean, come on, let's face it, there were so many of them. On 429, the same court minutes we were just discussing, there is something on the docket. It says, defense motion to continue, and then in the comments, motion to withdraw granted. So, I don't know what that means. I don't know what that means. Then on May the 2nd, we have a second amended notice for virtual depositions. These were Zoom depositions that they were trying to take with Sarah Zadowicz. So what they did was they kept those two, the medical examiner. Oh, they just took off the two detectives. I guess the two detectives weren't available, or I'm not going to be involved on that. I don't know why they changed the dates for them, but they did. That's all that does. Whole lot of, I guess that's stuff. That's the thing about legal paperwork. It's got to be done, but sometimes it's a lot of mumbo jumbo. To me anyway, because I don't know how to read it all. God bless you guys for coming in and being patient with me as I learn to follow these cases. This is truly I've only done a couple of trials, to be honest with you, so I'm learning. But I think the only way to learn is to dive in. So that's how I learn the best anyway. Amended motion to withdraw. So this is his amended motion to withdraw, which is very interesting. It was uploaded to the docket on 5/4 of 2022. And again, we're talking about Padilla, her technically second attorney. He says that the undersigned is forced to withdraw as reconcilable differences have arisen between undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. In other words, I want to tell you what a lunatic this woman is, but technically I'm not allowed to. Undersigned's relationship with the defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned's counsel's ability to effectively represent his client, especially preparing for trial. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. Interesting, right? So maybe the judge just said, look, I'm going to give you a couple days. Take the weekend. Go play a round of golf. Come back and see me on the night. We'll talk about it then. And Padilla was like, yeah, no, it only took me a couple of days. And really, as soon as I left your courtroom, I went ahead and told my secretary to write this up. And I'll just wait a couple of days before I send it to you. No, I don't know if that's what happened. I'm just stating that, thanks for the second chance. But yeah, for me to rethink that, I'm still traveling down that same highway. And I don't even know, I kind of wonder, it's attorney-client privilege, but I kind of wonder if he even met with Sarah again before resubmitting this revised motion, amended motion to withdraw. Probably not. I mean, maybe a phone call. I'd be interested to know. He could have met with her after court that day. They could have had a small discussion, and she kept on, knowing, and this also goes back to Sarah, okay? Because the attorney might have said, oh, okay, judge, I'll give it one more shot, or I'll think about giving it one more shot. And all Sarah had to do was keep her dang mouth shut. And she couldn't. She had to keep being Sarah. So thus we have her with no attorney at this time, being on May the 4th of 2022. Here we have correspondence from the judge on May the 2nd, or I'm sorry, May the 4th of 2022. What does the judge say? I don't know who this is to, right? Obviously, the clerk of court filed it. It's signed by the judge, but it just says on May 3rd, your correspondence has or have been received and is forwarded to the state attorney's office and the defense attorney. I don't know if he's talking about the letter or his motion to withdraw. All right, moving on. Next item. We got a notice of hearing for May the 10th, Tuesday, May the 10th at 2022 at 10:45 a.m. Okay. Movement counsel certifies that a bona fide effort to agree or to narrow the issues on the motions noticed has been made with the opposing counsel, or that because of time consideration, such effort has not yet been made, but will be made prior to the scheduled hearing. What does that mean? Well, under the where it says matter, which I consider the reference, defendant's counsel amended motion to withdraw and motion to continue trial date. So again, Padilla is still stuck in this poor thing on May the 6th and is asked to be back in court on May 10th. It seems like. Let's see if that happens. Oh, and then motion to withdraw. Second amended motion to withdraw. Wow. Okay. This is different. Okay, let's see what this says. Bless his heart, he really wanted out, didn't he? This was on May the 6th. Where's the date on this? 6th day of May. Okay. Same thing as before. Well, we're going to reread it because I don't know. The undersigned is forced to withdraw as irreconcilable differences have arisen between the undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. Okay, he's saying the same thing there. Undersigned's relationship with defendant has become adversarial. Saying the same thing there. Okay, part number 3. This is different. Undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with Florida Rule Judicial Administration, blah, 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 rules regulating the Florida bar are present, or wherefore the attorney-client relation has deteriorated to a point where counsel can no longer give effective aid in the fair presentation of a defense. So he threw in, he's like, okay, no, you don't understand. I really want out. Let me put some legal references here for you. We really want out. And then number 4 is undersigned appreciates the court providing him the opportunity to amend previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. He'll disclose information that may prejudice his client. Oh, just by giving specific as to why they're having such a hard time. I mean, it's the same thing in essence. Look, she's crazy. She won't let me do my job. She wants to run the show. Just like Daryl Brooks, she wants a secretary, not an attorney. She wants a secretary that has legal knowledge. Okay, maybe she wants a paralegal. That's what she wants. She wants a free paralegal. Well, she is running the show now, and she's freaking out. And she's saying, I don't understand. I'm unprepared. I don't know what to do. Is anybody else picking up the trend that maybe Sarah doesn't think past her nose? My mom used to say that sometimes. I was wondering what it meant. Now I get it. Now we're moving the depositions to May 31st for the 2 detectives on the case and Deputy Taylor. And their virtual depositions. At this point, it's May. In the last video, we talked about how COVID affected a lot of what they were trying to get done. In this video, we're not having that issue because COVID's been gone for over a year, or supposedly gone for over a year. Everything's kind of gotten back to normal after COVID. So they don't have the excuses, or I don't want to say excuses. They just don't have the roadblocks that they had before, I think, as far as time. Now we've got, now this is coming up again. Now they've already done this, so I'm kind of confused. As this was filed on May 10th of 2022. Order declaring the defendant indigent and appointing public defender. Okay. I guess they have to go through the motions of this again because they now have to go back to public defense. Okay. Who is the lucky person? Can you imagine the barrel turning? Like, this is what I picture. You guys close your eyes. This is what I picture. Okay, all these attorneys that are in Florida, these public defenders are in Florida, and they're like, oh God, shit, I'm in the raffle. I know my card's in the raffle. And let's say there's this big raffle machine, right? And it's sitting in the middle of this. You just remember how Sarah thinks they all meet up in the break room? Let's this huge break room, right? And somebody's spinning the little raffle wheel, and all the lawyers' cards are inside of it, and they're going to draw, and all these attorneys are sitting around, like, oh my God, about to just pee themselves, thinking, oh God, please no, don't, not me, not me, not me, not me, not me. Of course, at this point in time, they didn't know how bad it was, but that's what I imagine, just to give a visual. Now, the new attorney is not on here yet, right? The defendant is not in jail. The defendant shall phone the attorney's office within 3 working days for an appointment if one has not already been set. Well, she's in jail. A representative from the attorney's office shall visit the defendant within a reasonable time. You didn't give her a limit. You didn't give her a date. She's going to be all up in arms about that. What's a reasonable amount of time? To Sarah, that's tomorrow or this afternoon. So, that was their first mistake the court made. They had no idea who they were dealing with. Not that that's a good thing that she's like that. All right, now we'll go over to this one, which is the court order and set and reset notice. So now they're saying, okay, we are moving the pretrial conference to Wednesday, June the 8th. And I find it odd that the trial date is not set on here, but probably because we've got a new attorney coming in. They're going to have to figure out, or can we go to trial at this point? How much time do you need? Isn't that normally what happens when you get a new attorney come in? They've got to come in. They've got to get caught up on the case, see what was there. So, yeah. This case is going to set a world record for being somebody look it up in the Guinness Book of World Records. The trial date that was rescheduled the most. I wonder if there's such a thing. If you feel like Googling it, do it and let me know. While I'm going over this, y'all can do that. Okay, they sent something to Padilla. Y'all, look at this. This is so weird. Look at this paper. This cause came on this day for hearing. And then down here it says being now present. And then over here, being now present. What is it? That's so odd. Okay, this is June 8th. So are they telling Padilla? What are they telling Padilla? You're on this until June 8th? Maybe that's why he's on this. Technically you're still on this until June 8th until we get another attorney on it. I don't know. Ooh, motion for cost. We get back to the JAC stuff. I have a surprise for you guys when it comes to the JAC, by the way. I was recently contacted by someone who's going to help us understand things better. Defendant's motion to incur additional costs for electronic evidence expert and order the JAC to pay costs. The other day when I was going through these, I was getting so quick at going through them. I was like, bam, bam, bam. Now I got to stop. Okay, what is this now? The defendant seeks the assistance of an expert for cell phone tower analysis and computer and cell phone forensics. The state of Florida has indicated that they intend to rely in part on cell tower data to establish the defendant's presence at the crime scene. The state of Florida has indicated that they intend to rely in part on cell tower data to establish the defendant's presence at the crime scene, which still blows me away considering the fact that we've got video of her being there at the crime scene, but whatever. Analysis of the reliability of the state's evidence and methods is critical to the defendant's case and his right to due process. Electronic evidence expert John Sawicki, who's already been working on the case, Padilla hired him, has been previously appointed in this case. The defendant seeks to incur additional costs for him, again, at a rate of $200 per hour with an interim cap of $10,000. Okay, this is where I've got to stop. And not stop completely. I just got to stop and look back on my notes from the other day. When I was doing the first video on this, I had a tally running of everything they were requesting. This is the first time this has come up where So Wiki is asking for this kind of money, a $10,000. If this is not a resubmittal or anything like that, just for the record. Plus, all reasonable and necessary case-related expenses, including but not limited to travel from Tallahassee. Oh, he lives in Tallahassee. Great. From Tallahassee to Orlando. Lodging, meals, mileage, postage, shipping, long-distance charges, and document productions without leave of the court. Okay, I will say this. Probably what he's doing can all be done off-site. He doesn't need to be down in Orlando to get this done, I don't think. He can do it from his home in Tallahassee, and then he'll have to just be in court to show it or whatever, right? That's what I'm thinking. Again, this had been filed by Padilla's office, so it's still kind of relevant. It's still there because the hope is that whoever comes in and takes the case is just going to pick up where he left off, especially in dealing with the JAC. So this was dated on May the 16th. So let's go back and see what happened after this. Notice on 5/19. It's a one-pager. Notice of voluntary withdrawal of defendant's motion to incur additional cost for electronic evidence expert. Comes now the defendant, Sarah Boone, by and through the undersigned counsel, and hereby files this notice of voluntary withdrawal of defendant's motion to incur additional cost for electronic evidence expert, e-filed on May 16th, with regard to the above-styled cause. So this is the same. This is the $10,000, I would assume, from Wiki. So Wiki. But Padilla's the one that put it in. So maybe Padilla's like, yeah, I'm not going to be around. I'm pulling this out. Maybe this is the way it works when attorneys are turning stuff over to a new attorney. They're like, okay, anything I had scheduled, there's certain things that I don't know if they're going to want to go in the direction I went in. So if I've done anything, I'm going to pull back and let them kind of go their own way with it. And that maybe that's what's going on here. Then on June the 6th, so we're jumping up almost 15 days, almost 2 weeks ahead. Certification of conflict and motion to withdraw. Oh, shit. 2 weeks. This is an important. Okay, this date is much more important than I thought it was going to be. Okay. 5/10. 5/10 was when they technically May the 10th, right? May 10th, they assign the new attorney. They didn't say who it was, but they were going to be assigning a new attorney. They had the hearing on the 16th. This is how I believe it happened. On the hearing on the 16th, she had already met the attorney, probably via phone, or the attorney had come to the jail, and then they had their first hearing together. Then jump forward to June the 6th. Are you guys with me on this? I'm right here. Motion to withdraw. Filed on June the 6th by apparently the new attorney. Wait. This is interesting because attorney number 3 is Robert Wesley. Attorney number 3 is technically attorney number 1. So, for those of you that missed my first video on this timeline of events, where are my notes? Robert Wesley was the first public defender who was assigned on the case. The day after he was assigned was when Padilla swooped in and said, I know I'm going to take the case pro bono. So Wesley got to pull out. So technically Wesley didn't really I don't even know if you got to talk to on this case at all at that point. So he kind of sort of doesn't count, but still, if you're keeping count, he was attorney number 1. And again, he's going to be attorney number 3. When I was first looking at this, I read the signature at the bottom that said Eileen Forrester. And I was like, oh my gosh, that's the woman. But no, it's from Robert Wesley that must be his, yeah, that's his assistant. Okay. Let's see the reasoning of why he wants to. I'm thinking it could be a conflict of dates, and that may be all it is. But if he's talked to Sarah at all in this 2 weeks time period, it may be a lot more than that. The public defender was appointed to represent the defendant in the above-styled cause where she is charged with second-degree murder. The defendant's case is currently scheduled for pretrial conference on June 8th of 2022 at 9 a.m. A conflict has arisen such that the public defender can no longer effectively represent the defendant due to the fact that the public defender's office represented he represented Jorge Torrez Jr., who is the decedent in this case, in a domestic violence case where the defendant was the victim. That's why. Aren't y'all glad we go over all this stuff? So now we know. Totally doable. Let him go. There's a conflict of interest. But let's listen to what he says more in this, though. He says, there would be a conflict of interest for the public defender to continue to represent her as the interest of the defendant and Jorge Torrez Jr. were adverse, hostile, and irreconcilable. So good enough reason for us, right? I get it. So technically, Sarah gets a pass on that lawyer. But at the same time, that's lawyer 1 and 3. So she gets a pass on 2 lawyers. Still, it's a lot of lawyers she's gone through. Moving on to the next item on the docket, we go to June 7th. Withdraw, public defender, and appoint. Poor Judge Wooten. He says, well, damn, dadgummit, I thought I had this taken care of. All right. Once again, they're tired of typing it up, or it's just too much typing up. We don't have time for this. This is taking way too much. Just write it in. 7th day of June. We're going to have a pre-trial conference on June the 12th of 2022 at 9 a.m. We're going to set the trial for June 25th, 22 at 9 a.m. Done. Sign. In the meantime, get a public defender assigned to this case ASAP. I'm tired of this case. Then they had a hearing on June the 8th, the following day. And in that hearing, I'm assuming there's no notes. As you'll see here, there's no notes for the hearing. But on the 2 days later, there's some stuff uploaded on the docket. So let's see what this is. Notice of appearance, written plea of not guilty, waiver of arraignment, request for copy of indictment or information, and request for 10 days to file motions. Comes now David Verrett and enters this notice of appearance on behalf of the defendant. So, ding, 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 we've got a winner. David Verrett, Esquire, Florida Bar number 100814, Assistant Regional Counsel, Office of Criminal Conflict and Civil Regional Counsel, 5th District. He says, he is respectfully requesting all pleadings, every order not entered in open court, every motion written, every written notice, demand, and similar paper be served at the below noted mailing address. Send everything on this case to my office, i.e. He further says that the defendant, by and through undersigned counsel, shall respectfully request a copy of the indictment or information be forwarded to undersigned counsel at the below noted mailing address. Lastly, defendant, by and through undersigned counsel, respectfully request 10 days to file motions addressing the indictments or information. So, in other words, he needs 10 days to look over the files, I'm thinking, so he can figure out how he's going to move forward with his defense. You guys agree with that? Don't you think that's what he's saying? David Verrett. Never heard of him, guys. I don't know how long he was on the case. So let me put down attorney number 4. Maybe it's not Verrett. Maybe it's Verret. He might be French. Is he French? He could be. He sends out a demand for discovery, which is probably normal. Taking over the case. He needs a notice of discovery expressing the defendant's intent to participate in and election to avail herself of the discovery process provided by the rules, including the taking of discovery depositions. Undersigned counsel requests the prosecuting attorney disclose to undersigned counsel in permanent inspection copying, testing, and photographs of the information and material within the state's possession or control. So he did this on June 10th. She's got somebody in there that's gotten something on the court docket within 3 days, which I think is good because, it goes through its channels to get to the docket, right? Now, this is interesting. It says motion for disclosure of impeaching information on June the 10th of 2022. He filed this. It looks like there's tons of stuff he filed on the same day. So let's look at what he's talking about. The defendant and undersigned counsel respectfully move this court to an order directing the government forthwith to make inquiry and disclose all the following which is within the possession, custody, or control of the state's attorney's office or any other prosecutorial or law enforcement agency personnel, the existence of which is known by the attorney of the government or any member of the prosecutorial team. So it wants the criminal records of any proposed witnesses whose credibility may be an issue at trial, including the juvenile adjudications and pending criminal charges, any and all records and information revealing prior misconduct or bad acts, probative or untruthfulness attributed to proposed government witnesses whose credibility may be an issue at trial. Number 3, the present status of or any and all threats expressed or implied made to a proposed government witness as to criminal investigations, prosecutions, or potential prosecutions which are pending and could be brought against the witness. Any probationary, parole, or deferred prosecutions pending or which could be initiated against the witness, any tax, immigration, administrative, or judicial claim or dispute which may be instituted against the witness by the government or any state. I look at this and I think, is he just going, he's like throwing it back on the court going, okay, if she's got anything else, any other issues with the courts, let's put them all on the table right now. That's what and I could be wrong. That's what I'm kind of picking up. The existence and identification of each occasion on which a proposed government witness has testified, or after having been ordered to testify or given the opportunity to testify, has refused to testify before any court, grand jury, or other body, or otherwise narrated in relation to defendant or the facts surrounding the charges contained in the indictment. Any and all records and information which arguably could be beneficial or useful to the probative forces of the government's evidence, or which arguably could lead to such records or information, and any such records or information which minimizes the involvement of the defendant and as a result is material to punishment. All the above 5 items with respect to any non-witness or declarant whose statements will or may be offered in evidence during trial. Any documentary evidence which is inconsistent with the proposed witness's expected testimony on a material or substantial matter. Any written, recorded, or oral statement concerning a material or substantial matter, which was made by a proposed government witness, any individual interviewed by the prosecutorial team or co-defendant, or an unindicted co-conspirator that is inconsistent with the statements made by another individual. And breathe. Okay. Memorandum in support. Brady Law. I'm not going to read this whole thing, you guys. You guys know y'all don't come here for the legal advice. Y'all come here because I dig. So I think that was just, I'm going to just chalk that up to an attorney can explain that to you guys, but it's pretty much just going through the motions. Oh, wait a minute. What? So we did that impeaching information, right, on that document. Then on June the 10th, we've got another motion to withdraw by David Verrett or David Verret. So why don't we know anything about him? Well, because he probably got the trial he was assigned the trial on June the 7th, and he requested to get off of it on June the 10th. And his reasons are that the undersigned counsel was appointed to represent the defendant in the above styled matter. The regional counsel, 5th District, previously represented the witness Melissa Sexton in multiple cases. Oh, you guys, the apartment manager. Melissa Sexton is the apartment manager who said in her interview that she had spousal, she had DV. Y'all know what that means, spousal, and so he represented Melissa during that time period. So again, Sarah gets a pass on that one. Y'all are going to hate it when I find out she might get some passes. I know you are. We all want to hate her. She doesn't deserve Padilla's work so far. But these guys are like, thank God. It took me 3 days to find a client that conflicted. So it's kind of funny because he's doing all this paperwork. He's sending all this in. He's asking for all this information. I guess on the same day that they started filing all this stuff, they realized, oh, we do have a conflict. You poor little dude. You barely slipped by that one. You dodged that bullet big time. So Melissa's definitely going to be a witness, which we kind of figured anyway. They were already taking depositions for, but not everybody they take a deposition of are they going to call into trial, I don't think. We just know from Sarah's interview and Melissa's, and I think the other guy at the apartment, that Sarah was constantly going up to the office at the apartment. And Melissa was constantly having to go and tell them to quit bothering the neighbors with their noise and everything else. So there was a relationship that had established there, and Sarah befriended this woman. Sarah tried to play this woman's heartstrings with the whole DV thing. It was interesting. So we've got her interview also on my channel if you guys want to go back and listen to it. A couple of people made a comment that they didn't like the way she was laughing during her interview. I think she has a nervous laugh. I almost wonder if she's not going to get up on the stand and laugh a little bit. So just keep that in mind when you're listening to that, because some people do different things when they're nervous. Some people pant their leg, some people move their hands around. She obviously laughs inappropriately. So just keep that in mind. Let's not judge her until we meet her. And after we meet her, then we can judge her, okay? I'm just saying what's real. I'm just saying the truth. So, yes, she had multiple cases with her ex, I guess. I don't know how many exes, but she's had an abusive past. So we knew that. He just filed the certificate of conflict, which was normal. So now here comes the 15th, and we've got a notice of discovery, supplemental discovery. The state is coming out and saying we've got the following information available to the defense, and they've updated all of the items that are in the discovery at this point. And remember, we started this out, they were very, 100 pages maybe. Now we're up to like 300 or 400 pages, but and these are the items that Sarah is going to be looking at when they have their little private meeting. Have they had it yet? When did they schedule it for? I'll have to go back and look. I think it's in early September. Was it early September? I don't know. They're going to meet in private. They're not meeting in the court. So there's a CD with 911 call. There's a DVD with interviews, a DVD with videos from Sarah's cell phone, a DVD with public surveillance video, which we believe, myself and a few other subscribers believe, that is George going into Publix and buying the wine that they drank that night because they found the receipt for it. And one of my subs said in one of the comments, and thank you for whoever said this, and I apologize that I don't remember who it was because I read a lot of comments, made a comment that maybe by viewing that video, they'll be able to see that George didn't have certain injuries on him when he went into Publix. That it was that day or night. It was the same day of the event when he lost his life. So there's that. And then there's a DVD with photos. They're not getting detailed as to how many photos, but we know that there was, I'm not going to say the number. I don't remember the number, but I'm sure they'll have it in here somewhere. A DVD with a suitcase video and the device photos. So I believe that DVD is her cell phone. Well, but again, this is what I find to be different. They've got a separate DVD with just a suitcase video and device photos. Maybe those photos specifically deal with the case, or possibly could be part of what they're going to bring into the case. And the items listed up here under number 3 with videos from Sarah Boone's cell phone could be videos that were on her cell phone, but were not really relevant, or may not be, they're not using them in the case. I guess, I don't know why that's on there like that, but the DVD with the medical examiner's photos, and then we have the DVD with the audio interview with Brian Boone, Sarah Boone, and she's got 3 of them. He's got 2, and then it says cell phone videos. I believe the cell phone videos that they speak of when they say that are from the detectives or someone working on the case or neighbors or somebody. It's every time I look at that, it makes me question whose cell phone videos. But it's all part of the evidence. And then they've got an 8 gigabyte USB drive with the 3D scan. The 3D scan is what that guy was hired to put together, I think. No, I'm sorry. The state put this together, the 3D scan. I think that 3D scan, and correct me if I'm wrong, because I've been reading so much stuff, I forget sometimes. So if I read something and that it's not the same as this, tell me. But when I hear 3D scan, I think about them doing a play-by-play of how she had him in the suitcase. Like, he was put into the suitcase, he was moved over to this area, the suitcase was flipped over here, the suitcase went down the stairs here, the suitcase hit here, here, and here, and then, eventually it ended here, upside down, or whatever, you know what I mean? That's kind of where I believe that to be. So good for you, state of Florida. Keep us updated on what's going on there. All right, then the 622 order, I gotta log back in. Let me show y'all something real quick. You know how we were talking about the Guinness Book of World Records and the trials that have been scheduled and canceled and rescheduled? This is her hearing and trial docket. These are the scheduled hearings and trial dates. Whether they were put on the docket and canceled or not, they're all right here. June the 22nd. This is a form assigning Mark A. Consalo. I don't know how you pronounce that. June 22nd, 2022. This would be attorney number 5. Mambo number, what is that song? Mambo number. That's what it made me think of. Mark with a C. A. Consalo. Bless your heart. How long are you going to last? Let's see. Basically, just allowing the other guy to withdraw. And then appointing Consalo. Then, on the same date, 6/22, probably much of the same. Notice of appearance, request for a copy of charge, waiver of appearance at arraignment, and pre-trial conferences or written plea of not guilty. So, new guy's coming in with his cape on. He's flying in to save the day, whether he wants to or not. Then we have demand for discovery. I'm not going to open these because we've already saw that this is how it goes. Demand for discovery from the same dude. Oh, bless his heart. He lasted till July the 8th. Okay. Motion to withdraw on July the 8th. Somebody needs to count the time period in between. Who stayed the longest? I think Padilla won that race. Poor Padilla. What if they come back and said, you know what, you got to come back. We can't. We're sorry. You have to. Comes now the undersigned counsel, Mark Consalo, court-appointed attorney for the defendant, and hereby files this motion to withdraw and states as follows. The undersigned counsel has a conflict with his representation of the defendant that precludes him from further representation in the case. The undersigned counsel asks that a new court-appointed attorney be appointed to represent the defendant and that the undersigned counsel be relieved from all further representation in this matter. Well, Mark, isn't that vague? You're not going to get out of it that easily. Let's see what the judge says. The judge didn't even fight with him about it. Isn't that crazy? Well, I think at that point, now remember, we're going through the docket, okay? Just so you guys, I'm going through each item of the docket. We've only had one handwritten letter from Sarah. So Judge Wooten is not like, I don't think he's reached his peak yet with her. You know what I mean? So they're like, all right, fine, you're out. Frank Bankowitz, your number's been drawn. Has anybody seen Frank? Frank Bankowitz. Is he in the bathroom? Can Bueller? Oh, he's in the bathroom. Okay, well, when he comes out of the bathroom, can you tell him that he can go back in and stick his head in the toilet because he just won the Sarah Boone raffle drawing to be appointed as her attorney number 6. Now, I'm very familiar with Bankowitz because when this guy, I say, I'm familiar with Bankowitz's exiting this trial, this case. Not so much when he first started on it. So it'll be interesting to go through this. So keep in mind, last night I did 3 hours of recording on a video. I trimmed it down. It was less than 3 hours, but one attorney. Tonight, we've already gone through 4 attorneys. We're on the 5th, and we've only been recording for 1 hour and 10 minutes. So it just, to me, it says a lot. And I just wanted to bring that up for everyone. Okay. All right. All right. So on this, judge says fine. July the 11th, 2022, pretrial conference. Don't even type it out. What's this judicial assistant, Shanae, or whatever her name is down there. Asanya, Shanae, Shanice. Looks like Shanice, maybe. Shanice, Sharice. Don't even worry. Don't type it. Just write it in. Just write it in at this point. Pretrial conference 8/16/2022, 9 a.m. Trial at 8/29/22 at 9 a.m. And tell Bankwitz if he doesn't get his butt in here, I know where to find him. Did anybody else pick up on the fact that Bankwitz and the judge seemed a little friendly? Not like in a bad way. Yeah, we've worked together before type thing, you know? All right, back to the docket. On July the 12th of 2022, they had a pretrial conference hearing that was scheduled. Let me see something. But because they moved it back, they didn't state that it was canceled. They just don't put it. No, they did have the hearing. They had the hearing on the 12th. They did still have it. Okay. They're getting their dates together. And in speaking with Bankowitz was like, I need more time. Now, we did see that what I saw from Bankwitz is he had a lot of other things going on. He was trying to come in and tell the judge, look, I got this, and this. I don't know. I got to go to the hospital. He had health issues. I mean, he had a lot going on. But you know what? We all do. So, Frank, we all do. Now, the pretrial conference has been set for October 25th of 2022, and the trial is scheduled for November 7th of 2022 to accommodate Mr. Bankowitz familiarizing himself with the Sarah Boone case. Fair enough. Fair enough. Back to the docket. Defense motion to continue. Granted. I don't know what that means. I guess that means, okay, we're going to, oh, you know what I bet that is? Them saying, okay, we'll forward, we're going to push the trial back or whatever. Order setting pretrial conference on 7/12. 4 pages are right here on this document. Let's see what this says. Yeah, they're moving the trial. Okay, fine. We're resetting everything back. The pretrial conference and the trial date itself. Nothing specific on these forms, I don't think. anything specific to this case. This is all just normal. And if any of you guys are wondering, yes, this is the attorney that she called a buffoon. Electronic copy sent to private attorney. Okay. 7/15/2022. They send the copy to Bankowitz. Okay. Here's your trial dates. Bar calendar. Game on. On 8/16, they just canceled that trial and that pre-trial conference and the hearing for 8/29. That was normal because now they've moved it back. Notice of unavailability. 9/22/22. I think this is where Sarah starts getting frustrated with this guy. Wait, who is Dave Cassiatori? Oh, Dave Cassiatori. He's the assistant state attorney, which, you know what? I didn't even pick up that he was now in the picture. Bless his heart. Because that other guy had been on everything I've been looking at before. So I guess times change. I mean, 4 years go by, people change offices. So he's just letting them know he's got an approved leave from the office from November 28th to December 9th. He's going on vacation with his family. Okay, leave him alone. I don't think that affected the trial dates, though, did it? I can't remember what the trial dates were. Again, I'm not writing these down because it's just going to change again. Don't get too comfortable with any dates when you're dealing with this docket for Sarah Boone. Oh, letter number 2, everyone. And letter number 2 is here. Let me just look at one thing really quick. Okay, so Bankowitz, bless his heart, he was appointed on 6/22, right? He started demanding discovery, all that good stuff. So, I mean, June 22nd to October the 3rd, a little over 3 months before she started writing about him. And she wrote it to Bankowitz, but then it's kind of interesting, and I don't know if you guys were paying attention when y'all saw this, but it's referred to the judge. So maybe she thought this would never see the light of day in court. You know what I mean? I believe somewhere in my video library of this case, I have read this letter before. And again, this is just her complaining about how he doesn't call her, he doesn't visit her. The phone that she has for him doesn't work probably. Let me see what else it says. She only got a 15-minute video introduction with him on June the 14th. I will say that is pretty bad. It took him almost a month to go in there and talk to her. That is pretty bad. I'm not okay, y'all know I'm not pro Sarah. But if you think about it, he was assigned on June the 22nd. His office started filing paperwork on June the 22nd to get discovery and everything else. Why did it take him so long to get in there and meet with her? Or a phone call or something. She says, as of today, October 3rd, you have been my court-appointed attorney for almost 3 months. Sarah did the math for us. Why am I even trying to do it? 12 weeks, 84 days, and only spoken to me 3 times. July the 14th was a video introduction of 15 minutes. August the 2nd was a video update, 15 minutes. And August the 22nd was a visit in person for an hour and a half. She said, I've written 2 letters in the meantime. Also, my most recent I sent on September the 2nd with no response. I wonder if he ever made those letters available to the court after the fact, like when he started to withdraw. We're going to find out. So keep that in mind. If we find any letters that are older dated letters, that's what she's referring to here. She's unaware of the difficulties you're having in communicating with me, especially via phone, which to me is the simplest form of doing so. She just basically wants a phone call a few minutes a day, just a few minutes each day. He can have Sunday off. Really, Sarah? I believe by giving me your personal cell number, you were going to answer. This poor man, you should have called Mauricio Padilla before giving this woman your phone number. I think it's not really his personal cell phone. I think it's his work cell phone. He's probably one of those that has one for the office and one for the, don't you think, for an attorney? And he turns it off at night. I don't know. So she's just mad 'cause she hasn't heard from him. And I guess he's not answering her phone calls. But it takes her this much writing to get all of that out and let him know how frustrated she is. But at the end, she's very grateful, Mr. Bakewitz, for all you are doing and have done and will do. We're in this together, and I'm so blessed you are my attorney. God has put us in each other's paths for a reason, and I can't wait to see what you and he will do. I'm praying the 6 times a charm. She almost sounds like Letitia Stoutler. Just a little bit. A little bit. Whew. All right. Back to the docket. From judge to the defendant. I think this is where they notify her, yeah, Sarah, we got your letters. And guess what? We're going to give a copy of it to the state's attorney's office. Now, again, I don't know if this, because it doesn't say what documents. This is so stupid. This is really dumb to me. Why can't you at least reference what piece of document you're talking about? Is it the letter? Or is it all the filings to get all the discovery and everything? Sorry, didn't share it again. See how vague it is? Basically, whatever you just sent in, we're just putting it in the file. Now she's going to get upset because he shared her letter with the judge. Because she didn't write it to the judge. She didn't copy the judge. But I think this is where she gets upset because he does that. So now she's going to be like, well, that's fine. I'll write the judge then. I'll include him on everything. And Wooten looks over at Bankowitz and says, thanks a lot, Frank. Appreciate that. Notice of appearance, entry of plea, not guilty, request for trial by jury, and request for copy of charges. Bankowitz just put this in on October the 24th. Files this notice of appearance as attorney of record for the defendant, enters a plea of not guilty to the charges filed herein, requests trial by jury, requests copies of the indictment and or charges filed herein with endorsements thereon, and all notice of pretrial in our trial, request appropriate time for filing defensive motions. Now, my question when I read this is, she enters a plea of not guilty, so she has to plea every time she gets a new attorney? I guess that's how it works. I guess because each attorney may have a different defense strategy, every time they get in there, she again has to say, I told you I'm not guilty. I'm not guilty. But you are. Give me a minute, guys. I'm going to get better at sharing these documents with you guys eventually. Then on the same date, October the 24th, they demand discovery. Now, when you compare his response time to the other attorney's response time, I have to agree. He's moving like a turtle. And again, please don't get mad at me because I'm not pro Sarah, but I just think that when you look at it from the standpoint of, okay, this is what she was getting and expecting. I don't know what the correspondence was with her and the other attorney, whether it was a phone call or what. I don't know what kind of talking they were doing between each other because obviously that's attorney-client privilege. But we do know that between Padilla and the other guys, they were dropping in this stuff on the docket like bam, 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 getting it in there. And he's been on the case since June. And he's just now getting that in there. Then on the 25th of October, of 2022, the judge says, order substituting conflict counsel. This cause having come before the court upon the motion to substitute counsel conflict for the above-named defendant, and the court being fully advised in the premises, finds that the motion should be granted and substitution of counsel should be approved, and it is therefore ordered and adjudicated that, wait, what is this? That the office of the public defender is hereby relieved of any further responsibility in connection with this case. That the office of the regional counsel was not available or represented a co-defendant or witness. Under the authority, Frank J. Bankowitz, a member in good standing with the Florida Bar, practicing before this court, is hereby appointed as substitute counsel for this defendant and shall be compensated for services as provided in the Florida statutes pursuant to contract. The court-appointed counsel named herein shall immediately file a notice of appearance with a copy furnished to the assigned judge. I'm confused why that's just now coming up. Does this have something to do with him submitting orders to the JAC to get things done? Well, then they're saying copies shall be furnished to the newly appointed counsel. So any previous counsel should submit everything over to this guy now. But I'm still stuck on the fact that this is like 3 months later. This is happening. It didn't happen right away. Or within the first 30 days even. Then Bankowitz files a motion to continue. He said he wants the pretrial conference heard on October the 25th. Discovery is ongoing. The motion is made in good faith and not for the purpose of delay. Then he amended his notice of discovery for digital media. But this is the assistant state attorney. October 27th of 2022. State of Florida by and through the undersigned assistant state attorney and hereby places the defendant on notice that digital media evidence, such as body-worn camera footage, it doesn't say that, such as body camera videos, was previously disclosed in this case, and defense was sent a downloaded copy to download the digital evidence from evidence.com. Please note that some videos may contain geolocating information that may not be visible in the downloaded videos. If you would like to review the videos in the state's possession, please contact the assistant state attorney to make an appointment to review the videos. They're crossing their T's and dotting their I's. No big deal there. October the 28th of 2022, order on defendant's stipulated motion to continue is amended. They have now moved the case from November to January of 2023. Happy New Year, Sarah. You're not going to court until next year, girl. And the judge signs off on it. Well, this was the judge making this amended order on defendant's stipulated motion to continue. I guess that past motion was Frank saying, look, I've got a lot to look through. I need more time, judge. I imagine, though, if you're an attorney, in any job that you do, if you come in and somebody's already working that job, when you start a new job, it's just like starting a completely new job. You come in and you pick up where somebody else, left off. If you're in one of those positions to where you don't have to work with somebody else's past work or past product made or already started or, production area, whatever, it's fine. You can start from scratch. But when you come in and you've got to pick up where somebody left off, you're talking about a lot of catch up. So I get that. Then on November the 7th, we have, wait for it, another handwritten letter from Sarah Boone, November the 3rd, 2022. And she puts in parentheses, 4 weeks exactly since last letter. Oh, bless her heart. You guys, you can tell I've been doing the Deebrook School of Law videos because now I keep saying bless her heart. And I don't normally do that, do I? I don't think I do. Honorable Judge Wooten, forgive me in advance for having to utilize your invaluable time to ask the current progress of my case, but after not having any form of communication with my attorney appointed by you now after 11 weeks and counting, after sending 4 letters to my attorney appointed by you with no response, and after finally finding an outside resource to inform me of the uneventful, confusing filed documents online by my attorney appointed by you, I am still waiting with the perpetual question mark over my head. A friend told her what now? A friend said, girl, a friend. Is it really your friend, Sarah? Is it really a friend? Well, no, she didn't say friend. She just says, after finally finding an outside resource to inform me of the uneventful. It's pretty bad when you don't have any friends or family that'll help you look for stuff outside of jail when you're stuck in jail. It kind of says something about that person, does it not? I think it does. So again, in this letter, she's focusing her anger towards Bankowitz. And man, is she just going off. I'm not going to read this letter right now. I may do a video of just reading her letters. But I just kind of want to touch on what she's going off on. She's going through her frustrations. I guess there was a court date. I remember reading this one where she said she never waived her right not to appear. She wants to be there. What else can I do? Who can I seek help from? And then she turns around and says, I have you and God, Judge Wooten. If I do have an attorney, where is he? I mean, you're talking about 2 different personalities, and I do think that Bankowitz and Padilla had a completely opposite personalities. Bankowitz was kinda like, "Look, I've been doing this a long time. I'm just moseying along. I'm close to retirement." Padilla's, like, eager, aggressive, wanting to get his name out there, wanting to get his new law firm out there, it's totally different personalities. So she's seeing this and thinking that, But I do love how she always provides us with these dates that we don't have to go back and research because they're right here in her letters. I forget these. I really need to start going back and just utilizing all of her research. Now, she says he was appointed on 7/11. I didn't write it down. Was it 7/11? So it looks like she's getting all these motions or whatever, or all these notices from some. I guess this is her outside resource. Is that her? Is this outside resource? Is that Billy Lane? His company? I don't know. Notice of appearance for what? Had 3 years ago. Not guilty plea. Already filed. Yeah, I mean, he's not really giving her a whole lot of information. She might have been a bitch out the gate, though. In his defense, we don't know how she treated him right away. She might have already kind of had a way of working with the past attorney that she was just set on, and this old guy was like, that's not the way I work, lady. And it's all just what's going on. Why am I not hearing from anything? Why am I not getting copies of stuff? Grateful and patiently waiting, I await your response. Okay, back to the docket. Notice of hearing, November the 22nd. They're having a status hearing on Tuesday, December the 20th at 10:45 a.m. Probably just something new. Probably just like, okay, let's just touch base type thing, right? We're going to court in January. Where are we at? How we doing? Type thing. And plus, I want to be able to go on vacation for the holidays and not have to hear from you people again. That's if I was the judge. That's what I would be thinking. Okay. So then we've got correspondence filed from the defendant to the judge again on December the 14th. Happy freaking Thanksgiving. And oh, by the way, Merry freaking Christmas. Because she didn't get a response to her 11-3 document. I guess she suspected that she was supposed to get a written documentation from the judge of responding to her letters. She writes this letter, and she's got her little summary of progress. Numbers only, it's all I have. Once again, she's the victim. It says, He was appointed July 11th of 2022. 21 weeks ago, 147 days and counting. She last spoke to him on August the 22nd. 105 days ago and counting. She hasn't had a pretrial since October the 25th, so she doesn't know anything that's going on. Since her last letter to the judge regarding MIA attorney and case, November 3rd, 4 weeks, 32 days and counting. And then she even breaks it all down to the total number of hours in the day, I guess. No, I take that back. The total number of hours of time spent with client. Represented by client. Okay. So he's been representing her, according to her. I don't know how she does her calculations, but 3,528 hours and counting. The total hours of time spent with her, talking to her, working with her, too. Same questions. Where's my attorney? What's going on? Now she starts talking about her constitutional rights are being neglected. I get it. I mean, everyone knows more than I do about my case. Not fair, not fair. Not fair. It's not my fault. Significant. Nowhere. Unfair. Inappropriately. Wrongfully. Everything. Still everything. Still proud. Oh my God. This is the part that just always gets me. She's always got to go weird on these letters. I am blind and in the dark. This is wrong, unfair, especially for us still proud citizens of the United States of America, and it's unacceptable. There is more to everything, much more, and in which I've been patient to extreme to explain, interpret, and educate what now seems to be to the whole world. She's hopeful that the governor will be able to untangle the chaos and mistreatment. No one else seems to be able or willing to abide by the protocol of your justice system. She says our justice system, and rightfully, eagerly apply themselves. I'm hoping still these aforementioned topics can be further discussed at the hearing on the 20th, and in which I am bringing to everyone's attention prior. I have not heard from my court-appointed attorney to date, so I am unaware what else may be on the docket. It is time to finally move forward and in all the right ways. She's like a commercial. She's coaching a little league football game. She copied him, but she doesn't even know. Oh no, she goes, Mr. Banquets. Then she goes on to address Banquets directly. But what I find interesting here, and I don't know if I noticed this when I was reading this before, she's threatening the judge to go to the governor. Is she trying to get the judge's attention? Because I look at this document and it says, no action taken, return to file, received from judge. So then she just puts, this is like a little cover letter to him, to Banquets, to let him know that she's just not confident in what's going on with him. She's pissed because she goes, I believe the court and or judge would have sent copies to you of all my letters to them. But since I've been unsuccessful in receiving a response or update by their side also, I'm taking it upon myself to make sure everyone is aware I am still sitting here waiting on you. Please respond. I look forward to seeing you at the hearing, if not before then, with very much overdue and anticipated progress. Mm-mm-mm. And then after that letter, that was December the 14th of 2022. Motion to withdraw was filed on 12/19 of 2022. On or about July 11th, 2022, the undersigned was court appointed to represent the defendant in the above styled case or cause. Due to irreconcilable differences which have arisen between the undersigned, his client, and his family, the undersigned will be unable to effectively and properly continue representing the defendant herein. Now, as we all know, the judge was like, dude, we're going into Christmas, and you are not doing this to me now. This is the status hearing that was already scheduled for December the 22nd. He puts the motion to withdraw in on the 19th, right before the hearing. Old Frank ain't messing around. Wooten's like, yeah, we're still having the status hearing on December the 22nd. Court minutes 1222. They reset with judicial assistant. Mandatory appearance by defense attorney required at reset hearing. I don't know what that was. What does that mean, y'all? Then on 1227, court minutes, status hearing. Oh, December the 27th of 2022. Oh, man, this is in between Christmas and New Year's. That just sucks to have to deal with all this during the holidays. Defendant did not ask court to remove the attorney. Defendant's motion to withdraw is hereby denied without prejudice. The defense attorney is to coordinate meetings with the defendant prior to January 17th of 2023 pre-trial conference. The case to remain as previously set before. It was almost as if the judge here had to come in and go, okay, kids, stop fighting. Now look, here's what's up. No, we know you didn't ask him to leave. Shut up and sit down, Boone. And then he takes his hand and he points over to Banquets at the other side of the room. He goes, Frank, go see your client. Spend some time with your client. Tell her to quit writing me. You're still on this trial. You're not getting out that easy. I'll see you on January 17th. Happy New Year. Happy New Year. You lazy bastard. I don't know who said that. Oh, no. Here on the 27th, it just says defendant's motion to withdraw is hereby denied. 1227, it's the same stuff. Okay. Then on January 17th, motion for continuance. And this is when old Frank comes in and says, look, there's a lot here. If you're going to make me stay on this case, I need more time. Trial was set for January the 30th, and you wanted to have a pre-trial conference today to talk about the trial, and I am not ready for the trial. He says discovery is voluminous, but is ongoing. Okay, Frank, we'll give you some more time. Judge says it's a new year. I'm feeling good about myself. I've been on a diet. I'm going to give you some more time, Frank. I apologize if you guys don't like the way I'm making up this stuff, but I don't know. I need something to keep me going here. I need something. All right. Then we've got on. It was uploaded to the docket. Or it was done on January the 17th. And it's basically just resetting the trial dates. And we're resetting the trial date to April the 10th with a pre-trial conference on Tuesday, March the 28th. Court minutes say parties to coordinate a date for status hearing with judicial assistant. Defense attorney to schedule conference with defendant granted. So I will give it. I'll give Judge Wooten credit there because he's basically he shouldn't have to do this. He shouldn't have to go to his attorney. You need to call your client. You need to schedule an appointment with your client. You need to let her know what's going on. Because honestly, you guys, I don't care if he is technically, he's getting paid to be there. It may not be by Sarah, but he is getting paid by the JAC to do his job. You may not like her, but a lot of us have jobs we don't like. So he needs to suck it up and go see her and fill her in on what's going on. So don't get mad because I'm taking her side a little bit. But after going through all this stuff, my mind's kind of changing a bit on what kind of getting refreshed on the case more and more. Uh-oh. January 17th, 2023. Sarah writes a letter on January 10th. Oh, Lord. Happy New Year. Hello and Happy New Year. I hope the holidays were lovely and very memorable for you and your family. After she cussed him out and everything else in the last letter. I just wanted to check in as I have not heard from you since the status hearing back on December the 27th. And I wanted to confirm you're still my attorney after your motion to withdraw was filed on December the 19th of 2022. It is my understanding that you are, which is why I'm writing you directly. Oh, Lord. She says, I'm still unaware of what's going on with my case. Please see, in the meantime, please see below and thank you in advance for the information and clarification. She's saying, for this January 17th thing, I want to be there in attendance. What time, please? She hadn't gotten anything in the mail or heard anything about it. Waiver of appearance. Please mail or bring the appropriate documents to unwaive my appearances going forward. She addresses his reason to withdraw. She says it was not made known by you as my attorney or stated by the judge to the court during the status hearing. I was completely blindsided once again and still massively confused for the attempt, as our attorney-client relationship hasn't even been established from the 2 hours we've spoken. We barely know each other. And then she puts in there, now it's been 4,536 hours that he's had the case. So after saying, hello, how are you? I hope your family's well. Now she's getting into fussing at him. And here's why I'm mad at you. I'm mad at you, and here's why I'm mad at you. And this is what I want. So I'm going to piss you off, then I'm going to tell you what I want. And I'm going to tell you I want it now, and I want it yesterday. Again, I'll go over these letters later. I just don't have the bandwidth for her right now. Was I not sharing this tab, y'all? Again, I didn't share it. I keep forgetting. This is what it looks like. A bunch of... You know what? Wait, this reminds me of something. Her handwriting sure has changed since this first couple of letters. I will say that. But we have a saying that we do over here at our house where if someone's been drinking and they're getting a little bit tipsy, we'll say they're talking in cursive. Instead of saying they're slurring their words, they're talking in cursive. I think Sarah talks in cursive all the time. Order setting pretrial conference on January the 17th. This is pretty much what we've already done. This is just them doing this is what we're going to talk about. This is what's going to happen at the pretrial conference. This is the trial date. Get ready. Let's go. Let's do this. And again, just to keep everybody up to par on what's going on, the latest trial date scheduled while we are sitting here on this date of, what's the date? January the 17th of 2023, the trial was set for Monday, April the 10th. It's just the next one was just letting them know, confirming the dates or whatever. And then the judge sent out a notice of a status hearing for February the 3rd of 2023. I do feel like Judge Wooten was really trying to stay on top of this, like as much as he possibly could. This was sent on January the 25th of 2023. He probably said, I guess when they were having the court date, they were like, look, before we have the pretrial conference, we're meeting again. Because apparently I have to babysit all of you idiots. Because you can't get along. It does say on there, defendant's appearance is mandatory. You know what that makes me think? This makes me think that Wooten saw it coming, that he was going to amend his motion to withdraw. So he was like, all right, well, go ahead and make sure she's here because he's going to try this again and I might have to let him off the hook. Depending upon what's being said, I might have to ask her questions. We need her in the courtroom. I get it. I get it. Motion for cost for private investigator. On January the 26th of 2023, the defense requires the assistance of a private investigator to assist in preparing the defense in this matter, including but not limited to interviewing and locating witnesses, locating documents, performing background checks, and researching factual issues. The defense requests authorization for up to $10,000 at the rates established by law for private investigator services in this matter. Yet, what I find odd about this request is that he's not mentioning Billy Lane. What's the name of Lane's company? Something Investigates. Why is he not mentioning his company? It almost sounds like he's not familiar with the case. Are y'all picking up on that? Like, why would he do this if you've already got somebody there? Or, okay, here's why I'm saying this. Because in one of these other motions where somebody else had filed something, they made a comment about the one of the other paid witnesses or whatever, or experts. They're like, well, this person's already been on the case for a while. So we just asked that we need another, whatever. I think it was it Sawicki in the early part of this video. So we're gonna keep him on, but we need more money for him at this point. Why are we not? Surely they're going to come back and stay. I mean, well, we know Billy Lane stayed on it, so I just don't understand why Bankowitz is not addressing him. And Bankowitz is an old dude. I mean, maybe he's his health problems. Maybe he's at the point he should have already retired. I don't know. I'm not going to make excuses for him. I feel bad because I'm kind of bashing him a little bit, and I don't really know exactly the whole story, but I guess I'm feeling guilty for coming in and playing Monday morning quarterback. All right. Where were we at? We were January 23. If you stay on this website too long, it makes you reset. No, we're still in January. Keep going. Oh God, there's so much more. I need to look. When did Bankowitz come off this? Because if we have too much more of the docket, I'm going to have to extend this to another video because this is lasting a lot longer than I thought it would. Court minutes from okay. So then on February the 10th, we have court minutes. And it says, February the 10th, they all met in the courtroom. The defense to submit order for RCC to render discovery within 10 case to remain as previously set. I guess it's supposed to be within 10 days. Was this the hearing where he came in and he was like, I can't get anybody. I'm trying to get an expert witness. I almost want to go. You know what we're going to do in another video, upcoming video? We're trial prepping, right, you guys? I'm going to go back and I'm going to find every hearing that was put up, right? And we're going to watch it. Even if it's clips, I'll clip it together. Because what I want to know is why at this point in time, I want to connect the dots between what Padilla was. Because if you think about it, it really the case kind of went from Padilla to Bankowitz. If you think about it, as far as work being done on the docket, on the case. So that we can see. So I want to know where Padilla left off and where Bankowitz picked up. And did Padilla have something already set up and approved by JAC and Bankowitz completely ignored it? Or is it that Bankowitz is like, yeah, I know he did, but I don't know if I want to use his people. I'm going to use my people. Or I prefer to work with this person, or whatever it is. But we know that in one of the court appearances, Bankowitz was saying that he could not find somebody to work for the JAC rates that would also be willing to testify in the way that they wanted them to testify on behalf of Sarah. Now, we were all laughing and saying they don't want to be a part of her trial because they were like, they don't want to have nothing to do with Sarah. And I kind of agree. If you're coming from that, if you work with domestic abuse and you've got somebody like Sarah Boone on trial, nobody wants to have anything to do with her. I honestly, I don't blame them. But you're talking about somebody so what? I just thought Padilla had already found somebody. I don't know. I lost the train of thought. That's on 210. I'm going to make a note because we've got a lot of letters coming from Sarah that are going to come out. And then you got to remember, Wooten comes off the case, so we got to deal with that in the docket. Bankowitz didn't come off this until this past year, did he? Hang on, I'm looking for the motion to it. Here it is. Okay. It was August when Bankowitz, and they let him go. There's a lot in between there. Yeah, so I'm going to stop here for this video. I don't want to do these. I feel like if we do these in too long, if they're too long, people lose interest. It's too much. So I'll cut this one here. We'll pick back up again on the next time we do this docket. We're going to keep doing this till we get closer to trial, and we'll go from there. I want to thank all of you guys for being here with me today. I appreciate you, and I appreciate your time. I know you could be elsewhere. I know you could be watching on somebody else's channel, but I think I really appreciate you picked me. And if you're watching me and somebody else and you're watching all of us, then, well, good for you. I've had a lot of coffee today. Can y'all tell? Can you tell I've been drinking a lot of coffee? I'm all ramped up from doing that D. Brooks School of Law video. Which, by the way, I'm going to be dropping a new one very soon here. I don't know if I'll get it out before the weekend. I probably will wait till next week to drop it. But I do have another surprise coming up again, like I said earlier, for next week. And I think you guys are going to really enjoy this. It's going to be special. It's going to be different. It's going to help us understand this case better, too, I believe, and the procedures and whatnot in the background. Because we're so enthralled in this that we want to know everything about this case. One thing I've learned in doing the true crime community, I used to just love to watch documentaries before I got into like really studying and diving into these cases. And when I first started watching the people on YouTube that do what I'm doing now, I was like, wow, these people are like, they're like addicted to this. Like they're really into this. I was just going to watch the 48-hour special on it. I was going to watch the Dateline. I'm getting all this. So, yeah. So I know that people that watch these types of videos, like the one we just had, you guys are hardcore, and I'm here for it. I love it. And I don't do this on every case. Anybody that follows me knows I don't. So by the time the trial starts, all of us on this channel will be ready to go represent Sarah. So who knows? Maybe we'll all take a field trip. We'll meet up in the court. Do you guys think about this. Do you guys think that there's going to be like people like taking numbers to try to get in the courthouse to watch this case? Because I don't think it's going to be that much fun to be sitting in the gallery. I really don't. I'm hoping that this case is as good as we want it to be. I worry that because you see a different side of Sarah. You see the letter writing Sarah when she's sitting behind bars. When she's talking to you directly or when she's talking to the court directly, she only throws in like little digs every so often, she fits them in between sentences. But when she's writing a letter, she's like, oh, gung-ho at somebody. Have you guys ever dealt with somebody? They'll say it in an email, they'll say it on paper, but they won't say it to your face. That's a Sarah Boone. All right, you guys. Stay sane until I see you next time. Be good. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.